Question 1. Anis, Arisa and Alpha are partnered in a firm called 3A Enterprise. They have decided to appoint Sophia to assist in the management of the business, and one of the terms of the contract is that Sophia will receive 5% of the business profit. Subsequently, the firm suffered huge loss and was sued by its creditors. Sophia now seeks your advice as to whether she is a partner in the firm and thus liable for the firm's debt. Advise Sophia.
The issue is whether Sophia is a partner in the firm of 3A Enterprise and therefore liable for the firm's debt under Section 3, Subsection 1 and Section 4, Subsection C, Subsection 2 of the Partnership Act 1961. Whether partnership has been defined as the relation which subsists between persons carrying on business in common with a view of profit under Section 3, Subsection 1 of the Partnership Act 1961.
Rules for question 1. So, this case involved a relation which subsists between persons carrying on a business in common with a view of profit under Section 3, Subsection 1. Partnership Act 1961 and share of profit by payment of debt does not make the creditors, which is recipient, a partner in the partnership under Section 4, Subsection C of Partnership Act 1961. This section provides the circumstances which looks like a partnership but it is not a partnership. For number 1, Section 4, Subsection A, joint tenancy, tenancy in common, joint property, common property, or part of ownership does not create a partnership. Next is Section 4, Subsection B, sharing gross return does not create partnership. For the last section, which is Section 4, Subsection C, this section provides that a person is not considered a partner just because they receive a share of profits.
This section provides that a person is not considered a partner just because they receive a share of profit. There are specific situations where profit sharing does not mean partnership. A. Section 4, Subsection C, Subsection 1. A person receives the profit by installment or otherwise due to payment of debt. B. Section 4, Subsection C, Subsection 2. Remuneration of a servant or agent. Section 4, Subsection C, Subsection 3. Receipt of annuity by the window children of deceased partner. D. Section 4, Subsection C, Subsection 4. Specific loan on interest in writing attached with varying rate of interest. Last, E. Under Section 4, Subsection C, Subsection 5. Sale of goodwill.
Provision. We have chosen to focus on Section 4, Subsection C, Subsection 2, remuneration of servant or agent. If a servant or agent receives a share of profit as remuneration, payment for service, it does not make them a partner. They are only being paid for their work, not involved in the business as a partner. We relate this provision to the case Walker vs. Ish. Plaintiff was a clerk in the partnership. He advanced his money to the firm and signed an agreement which includes clauses whereby he would be paid a salary as a clerk plus 18% out of the business profit. The court held that the arrangement was not a partnership agreement but merely a contract of loan repayable when the plaintiff left the employment. By referring to Section 4, Subsection C, Subsection 2 decided case, a person is not automatically a partner just because they receive a portion of the company profits as stated in Section 4, Subsection B of the Partnership Act of 1961. Firstly, Sophia is entitled to 5% of the company profit and was hired to help with management. Moreover, the 5% of profit she gets seems to be compensation for her work rather than a partner profit share. In addition, Sophia was not considered a partner by third party despite the firm suffering significant losses and being sued by creditor. Furthermore, the agreement between Sophia and 3A Enterprise lacked the goal of operating a business together as partner. Besides that, Sophia made no financial contribution to the 3A Enterprise company, which is typically a crucial component in proving a partnership existed. Lastly, there is no evidence that Sophia had the power to sign contract on the company's behalf or make important decisions. She only helped with management.
Conclusion. Sophia is not a partner in the firm of 3A Enterprise and she is not liable for the firm's debt under Section 3, Subsection 1 of the Partnership Act 1961. The payment of 5% of profit is a form of remuneration, not evidence of a partnership relationship. Thus, she is not liable for the firm's debt and cannot be held responsible by creditor as a partner under Section 4, Subsection C, Subsection 2 of the Partnership Act 1961.
Created using Powtoon.